Hello everybody, welcome to iExamB. Embrace the iExamB learning experience. From today onwards, we are going to start discussion of previous year questions subject-wise, act-wise. And in this video, we are going to discuss the previous year questions from constitutional law that have come over the past 3 years, 2020, 2022 and 2023. This will give you an idea of the important sections and the areas from which questions have been asked. Constitutional law holds a weightage of 20% in Phase 1 Paper 2. This topic was earlier also a part of Phase 2, but now Phase 1 and Phase 2 topics are mutually exclusive. The topic of Constitution is present only in Phase 1 now. And the parts are also mentioned that you need to study from Constitution. The weightage for Constitution is 20%. There are 50 questions in total. So from here you can expect somewhere 10 questions. And if you see 2023 recruitment, there were 9 questions from constitutional law. So let's start with the discussion of previous year questions. The first question, this came in 2020 when constitution was adopted. You can see the options here. There are 5 options. The correct answer here is 26 November 1949. The constitution was adopted by the Constituent Assembly on 26 November 1949, which came into force on 26 January 1950. And again, there was another question when the constitution came into force. Remember, 2020 was COVID period. At that time, the questions that came in the exam were very easy. So again, here you have 5 options and you know the answer. It's 26 January 1950. Moving to question number 3. Words of the preamble were amended to add which terms? Which terms were added in the preamble? The correct answer is secular and socialist. The 42nd Amendment changed the description of India from a sovereign democratic republic to a sovereign socialist secular democratic republic and also added the words unity of the nation to unity and integrity of the nation. Question number 4. Which of the following words were added to the preamble by 42nd Constitutional Amendment Act? So you can see the amendment of the preamble came twice. Sovereign democratic republic, socialist secular, sovereign socialist democratic, justice social. You know the answer. It's a socialist secular. The correct answer is B. Moving to question number 5. If a state territorial extension needs to be amended, which of the following schedules of the Indian Constitution must be amended? First schedule, second, third, fourth, 12th, 7th. The correct answer here is first schedule. The first schedule contains the names of states and union territories. Territorial jurisdiction of states is also included. This question in different form was also asked in 2023. We'll come to that. Question number 6. In the Constitution of India, in the statement law inconsistent with or in derogation with fundamental rights, law includes. So what is included in this term law? Here you have again 5 options. So you can go through the options, you can pause the screen and then you can see what the answer is. The correct answer here is C. Any ordinance, order, bylaw, rule, regulation, notification, custom or usages having in the territory of India the force of law. So here you will be confused because you will see multiple options are there which are quite similar and all of them seems to be correct. So that is why you need to thoroughly go through the Bare Act to understand what all is included in every provision. Here you can see you will also find option A to be correct, option B to be correct, but actually you will have to find the most suitable answer. This question is from Article 13(3) of the Constitution of India. In this article, unless the context otherwise requires, law includes any ordinance, order, bylaw, rule, regulation, notification, custom or usage having in the territory of India the force of law. Then law in force includes laws which are passed or made by legislature or other competent authority in the territory of India before the commencement of this constitution and not previously repealed. So law is different and law in force is different. Now coming to question number 7, Article 14 of the Constitution of India states that state shall not deny to any person equality before law. So you can read all the options here, pause the screen, read the options and try to answer. The correct answer here is D. The state shall not deny to any person equality before law or equal protection of the law. This is given in Article 14. We had another question from Article 14 in 2023. Article 14 of the Constitution of India is related to. So you already know that it's related to equality before law. Article 14 deals with equality before law. The state shall not deny to any person equality before law or the equal protection of laws within the territory of India on all these grounds. Article 15 is right against discrimination. The state shall not discriminate against any citizen on grounds of religion, race, caste, sex, place of birth. Article 16 is with respect to equal opportunity in matters of employment. Article 17 is abolition of untouchability. Article 18 is abolition of all titles except military and academic. Coming to question number 9, Article 18 of the Constitution of India is related to. So you have already seen it's related to abolition of titles, as you can see from this slide. Article 18 is abolition of titles. In 2023, many questions came from the section numbers and article numbers. So you'll have to be cautious and remember important sections and important articles. This question was also in 2023 Phase 1 Paper 2. Question number 10. No person shall be deprived of his life or personal liberty except according to procedure established by law. This is given under. Under which article is this given? The correct answer here is B, Article 21. This is given under Article 21, protection of life and personal liberty. So you can pause the screen, you can read it there. Article 21 provides two rights, right to life, right to personal liberty. Then the next question is right to education is a fundamental right or it's a fundamental right under which article? Constitutional right, fundamental duty, both C and D. Correct answer here is option A, fundamental right as per Article 21A. Article 21A was added by 86th Amendment Act 2002, which provides free and compulsory education for all children in the age group of 6 to 14 years as a fundamental right. Question number 12, Article 21A question again came in 2023. This was added to what was provided through this edition of Article 21A. Free and compulsory education to all children of the age 6 to 14 years. Free education to all children of the age 6 to 14 years. So you can see the options are very close over here. Pause the screen, try to answer. We have already discussed this question. Correct answer is A, free and compulsory education to all children of the age of 6 to 14 years. This is in Article 21A. Question number 13. Which of the following writ order can be issued in case of illegal detention? Habeas corpus. So you know the answer. There are 5 writs and habeas corpus is issued in case of illegal detention. This is the most valuable writ for personal liberty. Habeas corpus means let us have the body. A person when is arrested can move to the court for the issue of habeas corpus. It is an order by the court to the detaining authority to produce the arrested person before it so that the court may examine whether the person has been detained lawfully or otherwise. And if the court is convinced that the person is illegally detained, it will issue orders for his release. Question number 14, another question on writs. Which of the following writs are present under the Constitution of India? Here there were 5 options having one or the other writ missing. So you just have to remember what all writs are there. The correct answer here is A, all the 5 writs are present. Article 32 in the Constitution of India mentions all the writs. The Supreme Court shall have the power to issue directions or orders including writs in the nature of all these 5. Next question, question number 15. The writ of certiorari can be filed before Supreme Court only, High Court, Supreme Court, before all courts within the territory of India, before collector, both C and D. Correct answer is B. Any of the writs can be filed before High Court and Supreme Court. Article 32 of the Constitution talks about the filing of writs before Supreme Court and Article 226 gives this power of writs to High Court also. Writ of certiorari is one writ which can be filed to obtain order of High Court or Supreme Court giving directions to the subordinate court or tribunal as to the order passed by these authorities. Question number 16. The provisions contained in Part 4 of the Constitution. Shall not be enforceable by court, shall be enforceable by court, shall not be enforceable, but it shall be the duty of the state not to apply these principles in making laws, shall be enforceable, but the principles therein laid down are nevertheless fundamental in the governance, shall not be enforceable, but the principles laid down are nevertheless fundamental in the governance of the country. Part 4 is related to directive principles of state policy. Correct answer here is E. These are not enforceable in the court, but these principles are fundamental in the governance of the country. So you can see there are minor changes in the options. Article 37 of the Constitution of India defines these. The provisions contained in this part, in Part 4, shall not be enforceable by the court, but the principles laid down are fundamental in the governance of the country, and it shall be the duty of the state to apply these principles in making laws. Moving to next question, question 17. Equal pay for equal work is provided under which part of the Constitution of India? Part 1, Part 2, Part 3, Part 4, 4A, Part 5. Correct answer is C, Part 4. Equal pay for equal work is a directive principle of state policy under Article 39. Article 39 under Part 4 of the Constitution provides for the principle of equal pay for equal work for both men and women. This provision ensures that both men and women have the right to an adequate means of livelihood. Question number 18. The provisions of separation of judiciary from executive is given under. Under which article this provision is given? So you'll have to remember the article numbers of fundamental rights, DPSP, fundamental duties, and other important provisions also. Correct answer here is B, Article 50 of the Constitution. Article 50 deals with the provision of separation of judiciary from executive. It provides that the state shall take steps to separate the judiciary from the executive in public services of the state. Question number 19. Education as a fundamental duty provides for education for the age group of 6 to 14, 0 to 5, 6 to 12, above 14, up to 14. If you remember Article 21A, that was a fundamental right where state was under the obligation to provide free and compulsory education for the age group of 6 to 14 years. Here the fundamental duty lies on parents for the same age group. Answer is 6 to 14 years. It is the duty of every parent to send their children between 6 to 14 years to school. Article 51A talks about these fundamental duties. There are 11 fundamental duties in total that are expected to be performed by the citizens. Earlier there were 10, but 11th was added by 86th Amendment. Question number 20. State Council of Ministers is maximum how much percentage of Legislative Assembly or Council? 25, 30, 10%, 5 to 10%, 15%. Correct answer here is 15%. The procedure for the formation of Council of Ministers at the state level is same as in case of Union Council of Ministers. Strength of State Council of Ministers cannot be more than 15% of the strength of State Legislative Assembly. This question was again asked last year in 2023. The total number of Council of Ministers shall not exceed 15%. Shall not exceed 15% of the total members of House of People excluding Prime Minister, including the Prime Minister. Then another option was with respect to 12% of total members of House of People including the Prime Minister. You can see the stress was either on the percentage or on excluding the Prime Minister or on including the Prime Minister. Not exceeding 15% of the total members of House of People excluding the Prime Minister. Not exceed 10%. The correct answer here is B, not exceed 15% of the total number of members of House of People including the Prime Minister. So Prime Minister is included and then the strength should not increase 15% of the total members of House of People. This is given under Article 75 of the Indian Constitution. The total number of ministers including the Prime Minister in the Council of Ministers shall not exceed 15% of the total number of members of House of People. Question number 22. An ordinary bill has to go through following stages to become an act. First, second, third readings and assent of the President. All stages as mentioned in option B. An introduction of bill in the second house. First, second reading and assent of the President. First, second, third reading only is enough as an ordinary bill. The correct answer here is 3. Actually, it's first, second and third reading, then introduction of bill in the second house and then assent of the President. So the correct answer over here is 3. All the stages which are mentioned in option B, an introduction of bill in the second house. This entirely is given as per Article 107 and 108 of the Indian Constitution. The options were not framed in this way. It was a little bit different. This is a memory based question. So remember the important articles here. Article 107 and 108. An ordinary bill is concerned with any matter other than financial subjects. It is introduced in either house of the parliament. Ordinary bill can be amended or rejected by Rajya Sabha and it can be detained by Rajya Sabha for a period of 6 months. After being passed by both the houses of the parliament, it is presented to the President for his approval or assent under Article 111 of the Indian Constitution. Question number 23. Article 129 of the Constitution states that the Supreme Court shall be a court of dash and shall have all the powers of such court, including the power to punish for contempt of itself. The correct answer here is Court of Record, Highest Order, Contempt, Government of India, Appeal. The correct answer is it's a Court of Record. Article 129 states Supreme Court to be a Court of Record, and as a Court of Record, the Supreme Court will have the powers even to punish for contempt of itself. Question number 24. The governor of any state may dash entrust to the state government or to its officers functions in relation to any matter to which the executive power of the state extends. Options are with the consent of president, without the consent of government of state, with the consent of government of India, on his own, on the direction of central government. Correct answer here is C, with the consent of government of India. So here you can see this is Article 258A of the Indian Constitution. The governor of a state may, with the consent of government of India, entrust either conditionally or unconditionally to that government or to its officers functions in relation to any matter to which the executive power of the state extends. Question number 25. Contingency fund is also known as emergency fund, can be used by Prime Minister anytime, is an impressed account to meet unforeseen expenditure, is at the disposal of Parliament, can be used to pay salaries of judges. Correct answer here is C. It is an impressed account to meet unforeseen expenditure. This is given as per Article 267 of the Constitution of India. Parliament may by law establish a contingency fund in the nature of an imprest to be entitled the Contingency Fund of India, into which shall be paid from time to time such sums as may be determined by such law, and the said fund shall be placed at the disposal of President to enable advances to be made by him out of such fund for the purpose of meeting unforeseen expenses, pending authorization of such expenditure by Parliament by law under Article 115 or Article 116. Next question 26. Assurance of property and contracts are made on behalf of the Government of India in the name of President, President or Governor, Ministers concerned, Cabinet Ministers, Prime Minister for Union Government and Chief Minister for concerned state government. The correct answer here is B. Assurances of property and contracts are made on behalf of government in the name of President or Governor as the case may be. This is given under Article 299 of the Constitution of India, which talks about contracts. All contracts which are made in the exercise of executive power of the union or state shall be expressed to be made by the president or by the governor of the state as the case may be, and all such contracts and all assurances of property made in the exercise of that power shall be executed on behalf of the president or the governor by such persons and in such manner as he may direct or authorize. Question number 27. Article 311 acts as a safeguard to civil servants except. So here you can read the options. Where President is satisfied that in the interest of security of state it is not expedient to hold an inquiry. Where the governor is satisfied. Where the Prime Minister is satisfied. Where doctrine of pleasure of President is applicable, both A and B. Correct answer here is E. Where President or the governor is satisfied. As per Article 311(2), Proviso B, where the authority empowered to dismiss or remove a person or to reduce him in rank is satisfied that for some reason to be recorded by that authority in writing, it is not reasonably practicable to hold such inquiry, or where the president or the governor, as the case may be, is satisfied that in the interest of the security of the state, it is not expedient to hold such inquiry. So usually Article 311 is acting as a safeguard to civil servants, but there are certain exceptions to it. The exception is where the president or governor is satisfied that it is in the interest of security of the state to not hold the inquiry. Question number 28. Parliament may by law provide for the adjudication or trial by administrative tribunals of disputes and complaints with respect to recruitment and condition of service of persons appointed to public services and posts in connection with the affairs of union, public services and posts in connection with the affairs of union or any state. So you can read all the options. Take your time, pause the screen, read all the options. Moving to the correct answer here is D. Article 323A talks about it. Public services and posts in connection with the affairs of the union or of any state or of any local or other authority within the territory of India or under the control of the government of India or any corporation owned or controlled by the government. So just read out Article 323A in detail. Question number 29. An amendment of the Constitution can be carried out by bill introduced in either House of Parliament, bill introduced only in Lok Sabha, bill introduced only in Rajya Sabha, bill introduced in Lok Sabha along with ratification by 2 or 3 state legislatures. There is special procedure prescribed under Article 369. Correct answer is A. Bill introduced in either House of the Parliament. So Constitution can be amended by bill introduced in either House of the Parliament as per Article 368 of the Constitution of India. This article talks about power of Parliament to amend the Constitution and procedure thereof. Question number 30. This is the last question. The names of states and union territories are given in First Schedule of the Indian Constitution, Second Schedule, Third Schedule, the Government of Union Territories Act 1963, State Reorganization Act 1956. Now these two options here create some confusion. The correct answer here is option number A, First Schedule of the Indian Constitution. Schedule 1 of the Indian Constitution contains a list of states and union territories and their extent and territorial jurisdictions. This was also a question in 2023. So there were 9 questions. These are all the questions from Constitution that have come over the past 3 years. I hope this gives you an idea what are the important areas from which you can expect question. You will have to read every part thoroughly that is mentioned in the syllabus. If you want to download the previous year papers, you can visit our website. There you will find the previous year papers of phase 1, phase 2 both, and you can easily download them, you can attempt them and check your score. In 2023 recruitment, 12 of our students got selected. There were 25 vacancies. 12 of our students were selected as SEBI legal officers, and we have guided many students over the past 3 years in their successful journeys of SEBI legal officer. We at iExamB help you prepare 50% faster with a crisp and concise content. Subscribe to our channel. Stay tuned. Thank you.